hearing on this appeal is 1 week from today, June 26th. And the question now is, will it work? Does he get a new trial? And what is the fallout if he does? Well, let's talk about him. Joined right now by former sex crimes prosecutor Nicole DeBorde, now a criminal defense attorney. Nicole, so good to see you. Thanks for coming on. So this latest effort is, again, fighting about the repressed memory evidence. Does he have a legitimate case here?
He really does. I don't think there's a whole lot of valid argument that still exists that the repressed memory theory is anything but junk science. And we ought to all be terrified that there are people potentially sitting in prison on the back of testimony or evidence which was submitted in court, which was essentially hypnotized or told to witnesses who then regurgitate it back after being in a state of hypnosis or some other type of allegedly therapeutic setting, having not remembered any such abuse prior to the hypnosis, and then being told it happened to them and retelling it in court. That is Nicole, just an absolutely dangerous way to conduct a trial.
This is not the first time he brought this up. A prior judge called this scattershot, this kind of argument.
I do understand that. The issue that these lawyers appear to be trying to raise is that this particular then what they declared to be valid science has been debunked and debunked again. In fact, even in the community of psychologists that once believed this to be a potentially viable method of getting information will tell you fairly consistently that there is no support for the idea of
but it has been used. It has been used in other prosecutions, and those convictions have been upheld, correct?
That's true. And, you know, long before DNA, there was ID testimony that came in, and we've now learned through DNA testimony that the wrong people were just sitting in custody because that was used in court and admitted. Well, you know, science evolves. We get smarter about the things we do in court, and that is what he's arguing this Court of Appeals should consider.
Wouldn't you say his case is different in terms of whether or not he even gets a retrial? But let's even get to a retrial. Why you say, okay, maybe this repressed memory therapy, it can't be used that alone to convict. You have an eyewitness who says they observed what was happening here. So isn't this a case that even if you say repressed memory, it's not enough for him to get a new trial, let alone for him to be acquitted?
So this is not about acquittal. This is about whether or not he should get a new trial free from infected evidence. And so certainly that very fact that you raised will be something that the Court of Appeals considers, whether or not, even if you take out all of the potentially unreliable, bad evidence that should have never gotten in front of this jury, would it still be likely that this jury would have convicted? And certainly that is a possibility. That's not the exact legal standard, but that's a question that the Court of Appeals will have to consider when they review these facts.
And I think at the very least he would say this jury that convicted me had a right to know another side to this repressed memory evidence. Another expert would, like you're saying, talk about how it's not actually reliable. The jury should have known that. Interesting discussion. We will see. Nicole DeBorde, thanks so much for coming on.
Thanks for having me.
Thank you for watching. Go to NewsNationNow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.